been a lawyer for over 32 years. People often ask me, do I need to probate a will? Can a deceased person's property be transferred without going to court? And what an order of no administration is in relation to the granting of a family allowance. Hi, I'm Mark. I'm a Texas attorney, and in this video, we're going to learn, do I need to probate a will? Or stated another way, is it necessary to probate a will? The answer to this question depends on the nature and extent of the assets contained within the estate. If the nature of the assets are personal property only, and there's no real property where a title needs to be transferred, you may be able to avoid the need to probate a will if you're simply transferring title to a vehicle. The Texas Department of Motor Vehicles has an affidavit of heirship form that you can use, as long as you confirm that there is no personal representative to be appointed to deal with debts of the estate. You're also required to have all of the designated beneficiaries sign the affidavit of heirship as part of the transfer of title to the new owners. Can a deceased person's property be transferred without going to court? It depends on the nature of the assets, whether the property is real or personal. In some instances, even real property can be identified as the appropriate heirs at law when there's no will by filing an affidavit of heirship in the county records. Can a surviving spouse avoid the effects of a will in Texas? It's possible that a spouse could file a claim for a family allowance and request an order of no administration under the Texas Estates Code, Chapter 451. In order to qualify for the family allowance and order of no administration, there are certain specific financial requirements that are part of the application process. You have to identify all the assets and debts of the estate, and excluding exempt property, the estate cannot have a value that exceeds $75,000. The application for a family allowance and order of no administration is limited to spouse, minor children, and adult incapacitated children. The idea of a family allowance for an adult child is a very limited opportunity. That's because an adult child cannot include the homestead as part of the exempt property. As a result, any estate that has assets in excess of $75,000, including the homestead, would mean that an adult person could not use Chapter 451. In order to seek a family allowance and order of no administration, you must also show that there has been no personal representative appointed on behalf of the estate to manage the assets and debts of the estate. You should also know that any time a court authorizes a family allowance and issues an order of no administration, any person that wants to ask the court to revoke that order must do so within 1 year of its execution. An application for family allowance must identify the assets and debts of the estate and must also confirm that the last illness expenses, the funeral expenses, and the attorney's fees made necessary for the application have all been paid. That's all the time we have. The outro music is coming. See you in the next video.